Najigorjan. Good morning, everyone. I'm up here this morning unsurprised. I was remiss yesterday in acknowledging the Gumatj people, the traditional owners of this land, on which me meet my sincere apologies. I had a stern talk to myself last night and it's not going to happen again. But it's good to be on your ancestral lands. I always feel very welcome coming here, and this occasion is no different. Now, before I begin, I have to stress that the Northern Territory Treaty Commission is not part of the Northern Territory Government. I'm not up here representing the Northern Territory Government, neither do my staff. We are independent of the government. My staff are independent. They can only take direction from me. I don't have to respond to any direction or request from the Northern Territory Government, depending on what it is. In 2016, around the election time here in the Northern Territory last year, in 2016, the Northern Territory Government committed themselves to have a conversation, whatever that means, with Aboriginal people of the Territory about a treaty. And in June last year, the Barunga Agreement was signed. It was an MOU between the 4 land councils and the Chief Minister. And a key commitment of that MOU was to appoint a Treaty Commissioner to guide the NT Treaty Commission. I was appointed in March this year, and as you've heard, Ursula was appointed last month now. So today I want to talk about a number of things, including what a treaty is, what my job is, and tell you a bit about what's happening outside of the Northern Territory jurisdiction in this place, in this space. So, the treaty sorry, I've flipped the wrong page. Sorry. I've written about a treaty years ago, nearly 30 years ago. I was looking back on some of the work that was done in the late 70s, early 80s. And the astounding thing that most of the literature is as relevant today as it was back then, because nothing much has moved. But a treaty is generally a settlement or an agreement that's arrived at by treating or negotiation. A treaty gives rise to binding obligations, unlike the MOUs in local decision making. They're binding obligations by the parties who make them, and they act to formalise the relationship between the parties who are part of that agreement. And as evidenced by modern treaty making between governments and First Nations peoples in Canada and New Zealand in particular, treaties are not restricted to agreements between governments. Treaties can be negotiated between states, between nations, governments and or people. Out of that Barunga Agreement that was reached last year, there are 3 crucial things that were agreed. Firstly, that Aboriginal people, the First Nations, were the prior owners and occupiers of the land, seas and waters that are now called the Northern Territory of Australia. Secondly, the First Nations of the Northern Territory were, and I'd suggest some still are, were self-governing in accordance with their traditional laws and customs. And finally, the First Nations peoples of the Northern Territory never ceded their sovereignty of their lands, seas and waters. Now, they're very important concessions in the treaty process because they're things we don't have to argue with the government over. We certainly have to argue and negotiate around how it's expressed in a treaty, but the acceptance of the facts makes it a little easier. Now, modern treaty making with Indigenous peoples could be thought of as having three key elements. Firstly, the recognition that Indigenous peoples are distinctive and differentiated from the other citizens within a particular country, state or territory. Secondly, settlement is achieved via an agreement negotiated as equals, in good faith and in a manner respectful of each party's equality of standing. And finally, that the government party recognises or establishes and resources and put in place structures of culturally appropriate governance with powers of decision making and control. In treaty making also, without exception, Indigenous peoples want the past examined, recognised and acknowledged, and take steps to try and repair some of the nastier things that have happened to Indigenous peoples through the colonial process. We heard yesterday about the Uluru Statement, and I think one of the key things about that is the creation of a commission. It's been called the Makarrata Commission. But we need some sort of commission to supervise the process of agreement making between governments and First Nations and for truth-telling. Part of my job is also to look at the legal and constitutional issues, particularly with respect to Commonwealth powers over a territory, particularly Section 122 of the Australian Constitution Act, where the federal government can make laws for the government of any territory. And of course, subsection 26 of section 51, which permits the federal parliament to make laws for the people of any race for whom it's deemed necessary. They're actually called special laws. The treaty process also, I think, up front needs to have some agreed standard that the parties will not go below. And it's been suggested that perhaps the United Nations Declaration on the Rights of Indigenous Peoples would set the standard that we cannot go below. And also what are known as the Van Boven principles, which deal with gross violations of human rights they could also be minimum standards. That was the standard adopted by the Australian Human Rights Commission in the Bringing Them Home report, the Stolen Generations inquiry. So it's not the first time we've used those principles in this country. If we take an international legal foundation, such as the United Nations Declaration of the Rights of Indigenous Peoples, that was adopted in 2007, and Australia, New Zealand, Canada and the United States voted against the resolution to adopt, the resolution of the General Assembly to adopt. They're the only 4 nations to vote against it. It had about 4 times the vote of the Universal Declaration of Human Rights in favour of it. And Australia and New Zealand, Canada and the United States capitulated, I think in 2012, and decided to withdraw their no vote, not without conditions. So the key points that are covered by the Declaration of the Rights of Indigenous Peoples are self-determination, participation in decision-making, respect and protection for culture, equality and non-discrimination, and specifically the right to be free from racial discrimination. And the Declaration also provides for treaty making, or modern treaty making, between states and Indigenous peoples. And it also provides for self-government as a legitimate self-expression of the right to self-determination of Indigenous peoples. So what's my job as Treaty Commissioner? So I said we're independent from the government. I am subject to a terms of reference that was developed between the Treaty Working Group and signed off by the Northern Territory Government. I also had some small input towards the end of the process. There's a process afoot at the moment to develop legislation to make my role a statutory appointment. And whenever I'm talking about treaty, I'm also talking about multiple treaties. So far, in the few months we've been active, there's a clear message coming to me that people want their own First Nations-based treaties or groups or regional arrangements. What's clear from my terms of reference, it's not my job to negotiate a treaty or treaties. That comes after I've done my job. So what I've got to do, and it's in 2 stages. Firstly, I have to consider and report on the level of interest in a treaty, what a treaty will seek to achieve and what outcomes are possible. A lot of that might be simple guesswork. Whether there should be one or multiple treaties, and it seems clear, as I said, that multiple treaties seems to be what people are saying at this stage. And what the best model for a treaty and the best process for negotiating treaties in the Northern Territory, and what might be in any treaty. So in the first stage, I have to provide a report to the Chief Minister. He has to release it within 21 days of receipt, release it publicly. And I have to, with my staff of course, and others, develop a discussion paper outlining some of the key issues that need to be consulted about. And I also have to report on the legal problems, constitutional legal problems the Territory has because it's a Territory, and report on possible models. In the second phase, we will use the the discussion paper as a template for our community consultations, which will start in April next year and run for 18 months. We're not heavily resourced to do this job, but we will try to get to as many people as we can. There's over 80 individual population centres in the territory that have more than 200 residents. 80 places would take us 5 or 6 years to do, I think, properly, but we'll do our best. The second part of my job is to report on the outcomes of those consultations. What are the recommendations, the next steps, and a proposed negotiation framework for a treaty to proceed in the Northern Territory. And that has to be 18 months from March next year. So what's happening in this space outside of the Northern Territory? Well, in Victoria they have the treaty advancement process. The Advancing the Treaty Process and Aboriginal Victorians Act 2018, which was assented to in July last year, set up the treaty process in Victoria. They appointed a Treaty Commissioner, Jill Gallagher. The Treaty Commission's role isn't to negotiate a treaty. Their job was to set up an Aboriginal representative body, now called the First Peoples Assembly of Victoria. And as I said, she's not. Once that assembly is set up, which will be in October this year, her job is done. And the First Peoples Assembly will work with the state to prepare the treaty negotiations. It also will be independent from the government, and it's set up to, as a treaty authority, to be an independent umpire in the negotiation process. They'll also set up a treaty negotiation framework. That'll be the ground rules of how the process will operate, and set up, importantly, a self-determination fund. This will support Aboriginal communities to be on an even playing field with the government. They'll also have an ethics council as part of the assembly in order to make sure that the process is in line with cultural appropriateness for the Victorian Aboriginal community. Interestingly, in Victoria, they've allowed 16-year-olds and above to vote for the Assembly, which I think is a very good thing, and something we might want to do here in the Territory. Talking about voices, we need to get the young people on board and hear what they have to say. I turn now to British Columbia, the British Columbia Treaty Commission. It doesn't negotiate treaties, it oversees the treaty process between First Nations peoples and the two governments, the British Columbian provincial government and the Canadian federal government. And many of them are, in part, treaties to settle native title claims. But they have a rigorous process, a 6-stage process of doing their treaties. You have to issue a statement of intent to negotiate. You then have to declare you're ready for negotiations. All three parties have to lodge that includes the two governments, and it has to be assented to by the other parties. Stage 3 is a negotiation of a framework agreement, negotiation of agreement in principle, a negotiation to finalise the treaty, and eventually the implementation of the treaty. And the treaties will address the First Nations government structures and related financial arrangements, jurisdiction and ownership of lands, waters and resources, cash settlements, and process for amending and resolving disputes. The one that I'm familiar with came into being before the British Columbia Treaty Commission was established, and the Nisga'a people of northern British Columbia. Their treaty provides for the authority to operate their own government and the ability to make laws. They got a bit over 196 million Canadian dollars in settlement as compensation. They got back over 2,000 square kilometres of their traditional lands. They got an annual allocation of salmon, entitlement to harvest other fish. They're important for the Northern Territory, of course, because 90% of the NT coastline is owned and controlled by Aboriginal people. It's off Aboriginal land, and some of them are surrounded by water, like Groot and Tiwi Islands and other islands. They also get allocations of moose and other wildlife species to their traditional tucker. They got a nearly $12 million to increase their participation in the general commercial fishery. So they've got an economic base, one economic base of many economic bases. There's a conservation trust, and the Nisga'a put their own money into that. And it's a bit like looking after country stuff. They have water reservations for domestic, agricultural and industrial purposes. Pretty important around mines, I think, for Indigenous people. And they've got funding to deliver health, education and social services to citizens and other area residents. Now, another one from our cousins across the ditch, as an international example for Maitarua, the Ngāi Tahu settlement. My apologies to New Zealand if I've mangled the pronunciation of the Maori there. But this settlement, and their modern treaty making, it's not really treaty making, it's agreements about disputes of the Crown, disputes or complaints by Maori that the Crown hasn't carried out their part so far as the Treaty of Waitangi is concerned. It's a breach of the treaty stuff. This group, the Ngāi Tahu, got an apology from the Crown. They got significant cultural redress, including provision of coastal space, and meaningful coastal space meant that they got land back that they owned and controlled. They've got a right to first refusal on any government assets, including land that the government might want to sell. And they got a knowledge of the role of Taonga Araki, which is Mount Cook, which was taken off them over a century ago. It was handed back to them, and they immediately gave it back to the Crown. The point being, it's ours to give away, not yours to take. And we want to share it with the rest of the nation. And they got economic redress in the form of a payment of New Zealand 170 million, and they also got interest on that, which was about 25 million New Zealand dollars. And this has allowed that mob to establish itself as an economic powerhouse in the region on the southern island. And today they have interest in fishing, tourism, property, as well as a diversified equity portfolio. One of the key aspects to self-determination is economic development. And you shouldn't forget that in treaty making. So that's just about me done. Thanks for listening, and happy treaty making. Galea.